Tuesday morning, coffee still hot. I push open the door my great-great-great-grandfather hung in 1839. And there's an orange lien notice stapled right into the wood. $3,580 from an HOA. An HOA that has nothing to do with this land. Never did. This farmhouse stood here before the Civil War. Before this county had paved roads. Before her subdivision was even a developer's daydream. I look up. Pearl white Cadillac. End of my drive. She's not lost. She's waiting. Arms folded. Watching my face like she bought a ticket to this moment. She rolls the window down and says, "You really should have just joined the HOA when we asked nicely." Then she smiles. Drives off. 185 years this land has been in my family. She had no idea what she just started. What would you do if someone filed a lien on land your family held for 185 years? Drop your state in the comments. Where are you watching from tonight? Let me back up and tell you who I am and what this land is, because without that, you won't understand what was really at stake here. My name is Garrett Weston. I'm 52 years old, a retired county surveyor, and yes, that detail is going to matter more than you think. I grew up on this property, left for 20 years to work in the field across 3 states, and came back 8 years ago when my father passed and left me the farmhouse. Not because I had to, because I wanted to, because some places pull you back. The Weston Farm sits on 42 acres of rolling bottom land in rural Harlan County, Tennessee. The main house, 2 stories, federal style, dovetail notched timber frame, limestone foundation, was built in 1839 by my great-great-great-grandfather, Elias Weston, a stonemason who came down from Virginia with a mule, a surveying chain, and a stubbornness that I can confirm is hereditary. The house has a smell that I can only describe as accumulated American time. Wood smoke from the fireplace we still use every winter. The faint ghost of linseed oil worked deep into the wide plank floors. Something between old paper and dried corn husks that lives in the walls themselves. The porch boards creak in a specific rhythm I've known since before I could walk. The kitchen door swells in August humidity and sticks the same way it has for 150 years. None of this is a problem. All of this is the point. When I came back, I threw myself into the restoration. I refinished the original heart pine floors myself. I repointed the limestone foundation with hydraulic lime mortar I sourced from a specialty supplier in Kentucky. Because if you're going to fix something that's been standing since 1839, you use materials that belong to it. I rebuilt the back porch from salvaged timber, milled from a tree that fell on the property. I am not a casual person about this place. Now, about a mile and a half down the ridge, in 2004, a developer named Prescott Grange clear-cut 40 acres of secondary hardwood and put in a subdivision called Ridgecrest Meadows Estates. 31 houses, vinyl siding, 2-car garages, a retention pond they renamed a community amenity lake, and a homeowners association with $185 monthly dues, and a 47-page covenant that included, I am not making this up, a clause prohibiting exterior paint colors classifiable as earth tones without prior written committee approval. Prescott Grange took his money and moved on. The HOA board he left behind did not move on, and the woman who had, by 2022, consolidated near total control of the Ridgecrest Meadows Estates HOA was a woman named Blythe Moorfield. Blythe was 61, recently retired from a mid-level HR position at an insurance company in Knoxville. She had come to Ridgecrest Meadows with the very specific energy of someone who had spent 30 years being managed and was finished with that chapter of her life. The HOA board was her kingdom. The 47-page covenant was her law. The twice-monthly board meetings, held in a clubhouse that smelled of industrial carpet cleaner and stale drip coffee, were her court. She drove a pearl-white Cadillac SUV. She wore coordinated athletic wear to board meetings as if they were a professional occasion. She kept, and this is not hyperbole, a 3-inch color-tabbed laminated variable binder dedicated entirely to covenant violations she intended to pursue. The first time Blythe drove past my farm, she slowed the Cadillac to nearly a stop. She looked at the barn with the 1887 weather vane rooster. She looked at the farmhouse that existed before her subdivision was a thought in anyone's mind. And something moved behind her eyes that wasn't admiration. Some people see something old and enduring and feel respect. Blythe felt something else entirely. It started with a letter. June of 2022. I'm on my knees in the kitchen garden, working Cherokee purple tomato seedlings into beds I've been composting for 3 years. Horse manure, kitchen scraps, the slow, patient work of building soil. The smell of fresh-turned earth is thick and good in the morning air. I hear gravel crunch in the driveway and look up to see a man I don't recognize walking toward the porch with the body language of someone delivering news he didn't write and doesn't endorse. He hands me a letter on Ridgecrest Meadows Estates HOA letterhead. I read it standing there with dirt on my hands. The letter informs me that my property is in violation of Ridgecrest Meadows Estates community standards on 4 separate counts. 1. Unpermitted agricultural structures, meaning my barn, built in 1887. 2. Unpermitted exterior storage, meaning the vintage John Deere tractor I used to bush hog the back acres. 3. Improper vegetation management within 50 feet of a shared road corridor, meaning the wildflower meadow I planted along the county road, which I had cleared with the county and which was certified monarch butterfly habitat by the State Agricultural Extension Office. 4. Failure to register as a member of the HOA and remit 18 months of back dues. $3,330 total, plus a $250 administrative fee. I read it once. I read it again. Then I do something important. I don't laugh it off. I don't crumple it up. I set it on the kitchen table, wash the dirt off my hands, and start pulling files. I am a retired county surveyor. I have the original 1839 deed for this property, the 1952 survey replat, the 1987 title search my parents ran when they refinanced, my own 2014 survey from when I came back and started the restoration. I spread these across the kitchen table with the calm efficiency of someone who has spent a career doing exactly this kind of work. The western property boundary is entirely outside the Ridgecrest Meadows Estates plat. No overlap, no shared boundary line, no instrument of annexation, no recorded covenant running with my land. There has never been a recorded covenant running with this land. The 2 properties share a county road, the same road shared by every property on this ridge, and that is the full extent of our legal relationship. I write back. My letter is polite, precise, 3 paragraphs. It explains that my property predates the subdivision by 165 years, attaches my survey data, notes that no covenants have ever been recorded against my parcel in Harlan County, and requests that the HOA direct all further correspondence to my attorney. I didn't have an attorney yet, but it sounded good. Blythe reads my letter at the next board meeting, aloud, in a tone that says she finds it amusing. He says he's not in the HOA, she tells the board. 3 of the 5 board members shift uncomfortably in their folding chairs. He thinks he's not in the HOA. Here's what Blythe had done, and this is the moment where petty crossed into genuinely dangerous. In 2019, the board had passed an internal resolution declaring that any property within visual and road corridor adjacency of the subdivision was subject to HOA aesthetic standards as a matter of community character protection. It was legal nonsense. It had never been tested. No attorney had reviewed it. But Blythe had found it in a binder left by the previous board president, and she had decided it was a weapon. She filed the lien. Not a warning, not a second letter. A lien, filed with the Harlan County Register of Deeds, against the Weston property for $3,580 in alleged unpaid dues and fees. I find out when my banker calls. I'd been quietly working with a community agricultural heritage loan program, low-interest capital for historic property restoration. The lien stops that process cold. An encumbrance on the title means no new financing until it's resolved. It shouldn't be there, my banker says, but it is there, and until it's discharged or contested. I know, I tell him. Outside the kitchen window, the weather-vane rooster catches the afternoon wind and spins. I hang up. I make another call, this time to find a real attorney, and I start taking notes. The attorney I found was a woman named Sable Okafor, a property rights specialist out of Knoxville, who had built a reputation handling overzealous HOA enforcement cases across rural Tennessee. Her desk looked like organized chaos, stacked case files, color-coded sticky notes across her monitor, a coffee mug that read, "Adverse possession is a love language." She was sharp, direct, and when I walked her through the situation, the surveys, the lien, the internal resolution, She said something I'd repeat many times over the following months. This isn't a gray area. This is absurd. And absurd cases make excellent case law. Sable laid out our path. First, a formal demand letter to the HOA board requiring them to voluntarily release the lien within 30 days. The letter would cite the absence of any recorded covenant running with my land, the absence of any valid instrument of annexation, and the Tennessee Property Owners Association Act, which governs HOA authority and is quite specific about the legal prerequisites for imposing dues obligations on a property. The takeaway? Under Tennessee law, an HOA cannot impose dues or file liens against a property that was never subjected to its covenants by a recorded instrument. No recorded document, no authority. Full stop. Second, a simultaneous complaint to the Tennessee Real Estate Commission, flagging the lien as a potentially fraudulent encumbrance. Third, and Sable said this with a slight smile, a public records request to Harlan County for every document the HOA had ever filed. Every correspondence on county letterhead, every permit application they'd ever submitted. Why the permit applications? I asked. Because HOAs that file bad liens against people, they don't govern, often have other paperwork problems, she said, and I like to know what I'm working with. The demand letter went out certified mail on a Thursday. Blythe received it on a Saturday. Monday morning, she convened an emergency board meeting. I would later obtain the minutes through the public records process. And they are, genuinely, a document of a person who has never been seriously challenged, telling herself she's still winning. The minutes reflect that Blythe described the demand letter as aggressive and legally uninformed, and moved to retain the HOA's management company's in-house counsel to respond. The motion passed 3-2, the same two board members who'd been shifting uncomfortably now voting against. The in-house counsel, a man named Doyle Fincher, who handled contract work for the HOA's management company alongside a personal injury practice, wrote back with a letter that was, charitably, not his finest work. He argued that the HOA's 2019 internal resolution constituted a constructive covenant under Tennessee common law, that my property's proximity to Ridgecrest Meadows created a shared community interest, and that the lien was therefore valid and would not be released. Sable read this letter, set it down, picked up her coffee mug, took a long, slow sip. Constructive covenant, she said. He actually wrote that. Here's the thing about constructive covenant as a legal theory. It doesn't exist the way Doyle Fincher was using it. A covenant running with the land requires a recorded instrument, agreed to by the landowner, meeting specific requirements of intent, touch and concern, and privity of estate. You cannot retroactively impose one by passing an internal board resolution and calling it constructive. This isn't a technicality, this is foundational property law. The takeaway: you cannot create a binding covenant against someone else's land without their participation and a recorded document, no matter what you call it in a meeting. I, meanwhile, had been doing my own digging. The public records request came back thick. 247 pages of filings, correspondence, and permit applications. I went through every page with a yellow highlighter and a legal pad, the same way I used to go through survey plats and legal descriptions for 20 years. Methodical, patient. I found 3 things of interest. I set them aside in a manila folder and wrote on the tab, in my old surveyor's hand, for later. Outside, spring turned to summer. The monarch butterflies came back to the wildflower meadow along the road, working the blooms in the long afternoon light. The weather-vane rooster spun in the warm Tennessee wind, indifferent to all of it. I was not indifferent, but I was patient. Blythe escalated. If the first letter had been an opening move, and the lien had been a power play, what happened in August of 2022 was something different. Something that felt less like a legal dispute and more like a personal campaign. Blythe began showing up. Not on my property. She wasn't that reckless. But she was there, parked at the shoulder of the county road in her pearl-white Cadillac, sometimes for 45 minutes at a stretch, a notebook open in her lap. Neighbors who drove past would later tell me they'd seen her out there 3, sometimes 4 times a week, writing things down. She was building a file on me. She filed 2 additional complaints with Harlan County Code Enforcement. The first alleged my farmhouse restoration work was unpermitted construction activity. The county inspector who responded to this, a man who had known this property for 20 years, cleared the complaint in 48 hours after reviewing my permit folder. Every document in order. He called me afterward and said, in a flat voice, "You've got all your papers, Mr. Weston. This one's closed." The second complaint alleged my wildflower meadow contained invasive non-native species constituting a nuisance. The County Agricultural Extension Office, the same office that had certified the meadow as monarch habitat 2 years earlier, responded with a letter that was politely but unmistakably contemptuous of the complaint. Then Blythe went online. She created a Facebook group called Ridgecrest Meadows Community Standards Watch, and began posting photographs of my property with captions like, "This is what our neighborhood has to tolerate while we pay our dues and maintain our homes," and "Some property owners in our area feel the rules simply don't apply to them." The posts spread through the subdivision. They also got noticed by people outside it. One of those people was a man named Thaddeus Birch, a freelance journalist based in Knoxville, who ran a small regional newsletter covering local government and property rights. A few thousand subscribers, but a specific audience: county commissioners, planning board members, real estate attorneys, local activists, people who paid attention to exactly this kind of thing. Thaddeus drove out to the farm on a Thursday afternoon in early September. I made coffee. The kitchen in late summer smells of basil and ripe tomatoes from the garden, and the old limestone walls hold the day's warmth even after the sun drops behind the ridge. It's the kind of room that makes people want to sit and talk. So we sat and talked. I showed him everything: the surveys, the lien, the demand letter and the HOA's response, the Facebook posts. He asked one question: "Have you gotten to the bottom of that manila folder yet?" I smiled. "I have," I said, "and I'm waiting for the right moment." Thaddeus published a piece the following week. Careful. No conclusions, just facts laid out clean. The age of the property, the lien, the legal theory the HOA was advancing. He quoted Sable briefly. "What's been filed here is, to put it plainly, a lien against a property this association has no legal authority over." 2 regional news outlets picked it up. Blythe called an emergency board meeting that same afternoon. The minutes, obtained later, show she told the board the coverage was biased and inaccurate, and proposed hiring a PR consultant to manage the narrative. The board voted 4-1 against. The dissenting vote was Blythe's. The 2 board members who had been shifting uncomfortably for months, a retired civil engineer named Weston Pruitt and a retired school teacher named Darlene Gage, exchanged a look after the meeting that said something without words. Weston sent Sable an email the following day. He said he was reaching out in a personal capacity, and that he thought the board needed to hear some things it wasn't currently hearing. Sable forwarded it to me with one line: "It's starting to crack." I read it at the kitchen table, the manila folder sitting right beside my coffee cup. It was time to open it. The manila folder had 3 items in it. The first was a 2007 county permit application for the Ridgecrest Meadows Estates entrance structure, the brick and wrought iron gateway at the subdivision's entrance on the county road. The application listed the structure's setback from the road right-of-way as 12 feet, the standard requirement in Harlan County, 15 feet minimum. The structure had been built at 12 feet. The permit had been issued anyway. Whether through oversight or something else, I didn't know yet. But that entrance gate, which had stood there for 15 years, was sitting 3 feet inside the required setback. The second item was the 2019 board resolution itself, the same one Blythe had used to claim authority over my property. What I had noticed, and what nobody else appeared to have caught, the signature line. The resolution was signed by 3 board members, but the HOA's own bylaws, recorded with the county in 2004, required a minimum of 4 board member signatures for any resolution with financial or legal effect on non-member properties. At the time of the 2019 signing, the board had 5 members. Only 3 had signed. The resolution was procedurally void under the HOA's own governing documents. The takeaway: the legal foundation for the lien was a resolution that didn't meet the HOA's own signature requirements, making it internally invalid before it was ever challenged from the outside. The third item was the most important. In 2021, Ridgecrest Meadows Estates had applied to Harlan County for an expanded stormwater easement that would have extended the HOA's maintenance responsibility and, critically, their legal claim of jurisdiction along the county road corridor. The application had been denied. The county engineer's denial letter stated plainly that the requested easement would encroach on parcels not party to this application, including the Weston agricultural property, a historically recorded pre-plat parcel. In other words, the county had already, on the record, specifically named my property as outside the HOA's reach. The HOA had tried to get legal authority over that road corridor and had been denied in writing. And then, the following year, Blythe had filed a lien as if that denial had never happened. I sent all 3 items to Sable. She called back within the hour. She is not someone who uses strong language casually. She used it now. Then she said, "The lien isn't just legally unfounded. It was filed after a documented county denial of jurisdiction. That's not negligence. That could be construed as the deliberate filing of a fraudulent encumbrance. That's a different category of problem." In Tennessee, knowingly filing a fraudulent lien is a Class E felony under TCA Section 29-23-201, the state's fraudulent lien statute. The takeaway: Tennessee's fraudulent lien law carries criminal penalties, and the person who authorizes a lien they know to be without legal basis can face personal criminal liability, not just civil consequences for the organization. I sat with that for a long moment. Outside the kitchen window, the first cool breath of September had come through the hills, and the late afternoon light was long and golden, the way it gets in early fall. The weather vane threw a shadow 30 feet across the yard. "I don't want her in prison," I said. "I want her to understand what she did." "I think," Sable said carefully, "we can arrange that." There is a particular satisfaction in watching a plan come together when you've spent a career building things with precision. I am a patient man. I spent 20 years reading survey plats, finding the exact line between what's yours and what isn't. This was the same work, just different tools. The first thing Sable and I agreed on was sequencing. You don't fire everything at once. You build a structure, legal, documentary, public, and you let the other side keep walking toward it. Sable filed a motion in Harlan County Chancery Court to quiet title, a formal legal action asking the court to declare, on the record, that no valid covenant, lien, or HOA authority had ever existed with respect to the Weston property. If successful, a quiet title action produces a court order filed with the county that becomes part of the property's permanent title history. No future HOA, no future developer, no future Blythe could ever again attempt to claim authority over this land without confronting a recorded court ruling. The takeaway: a quiet title action is the nuclear option in property disputes. It permanently clears the record and creates a legal barrier against all future claims. Simultaneously, Sable filed a complaint with the Tennessee Attorney General's office, flagging potential violations of the Tennessee Consumer Protection Act, specifically the provision prohibiting unfair or deceptive acts in connection with real property transactions. Filing a lien on property you have no authority over, particularly after a county denial of jurisdiction, is exactly the kind of thing that AG offices find interesting. I worked my own angles in parallel. I met with Weston Pruitt and Darlene Gage separately, both at the Farmhouse, over coffee. Weston turned out to be a retired civil engineer who had been quietly uncomfortable with the board's direction for over a year. Darlene had joined the board to improve the neighborhood playground and had found herself sitting next to a woman with a binder and a mission she hadn't signed up for. Both were willing to provide sworn statements about the board proceedings, the signing irregularities on the 2019 resolution, and Blythe's specific role in directing the lien filing. Those statements went to Sable, and in summary form, they went to Thaddeus Birch. The setback violation on the entrance structure was my work to document. On a Saturday morning in late September, dew still heavy on the grass, the air carrying the first real bite of fall, wood smoke drifting from a neighbor's chimney down the ridge, I walked to the county road with my survey equipment and shot the measurements the same way I've done 10,000 times in my career. 12 feet 2 inches, 3 feet inside the required setback. I prepared a formal survey memo and filed a code enforcement complaint with Harlan County. not out of spite, because the setback violation meant the entrance structure was technically an encroachment into the county road right-of-way, which had its own legal implications for the HOA's property claims. The county engineer's office, which had already denied the HOA's 2021 easement application, received this complaint with what I can only describe as visible relief. Then there was one more piece, my idea, not Sable's. The annual Harlan County Agricultural Heritage Festival was held every October at the county fairgrounds. 3 days of antique equipment, seed-saving workshops, and walking tours of historic farm properties. I participated before in a small way. This year, I called the organizer and asked if the Weston Farm could anchor the walking tour, with a full exhibit on the property's history and restoration. He said yes immediately. I invited Thaddeus Birch, the county historian, the state agricultural extension director, who had certified my monarch meadow and was, after Blythe's code complaint, personally invested in this situation. The Harlan County Register of Deeds, a woman named Patrice Hollowell, who had been quietly troubled by the lien filing since the day it crossed her desk. And this is the part Sable called elegant. I filed a formal request for the Ridgecrest Meadows Estates HOA board to appear at the festival's public forum on agricultural heritage and property rights as a stakeholder in county road corridor management. Sent by certified mail to the HOA's registered address. Professional. Reasonable. Completely routine in appearance. Blythe R. SVP'd yes. Of course she did. Blythe was not the kind of person who turned down a public platform. She had no idea it was already someone else's stage. October came to Tennessee the way it always does. Suddenly, dramatically, like the hills had been waiting all year for permission. The maples along the ridge went orange-red in what felt like a single night. The morning smelled of cold creek water and wood smoke, and the light came sideways through the trees in long amber shafts that turned everything golden. I have loved this farm in every season, but I love it most in October. Blythe, sensing that something had shifted, without knowing exactly what, began moving faster. She filed a third code complaint against me, this one with the State Environmental Agency, alleging potential soil disturbance violations related to the farmhouse restoration. This complaint had even less basis than the others. My restoration had used traditional materials and methods specifically chosen to avoid triggering modern environmental review requirements, and I had documentation for all of it. But the point wasn't to win the complaint. The point was to generate paperwork, create delays, and signal, to me and to anyone watching, that the cost of fighting would keep going up. It's a tactic that works when the other side can't afford the friction. Blythe had used it before. In a previous dispute with a Ridgecrest Meadows homeowner, who'd painted his shutters the wrong shade of gray, she had filed complaints and demanded inspections until the man simply repainted to make it stop. I was not that man. The State Environmental Agency responded, reviewed my documentation, and closed the case in 11 days. But before they closed it, an investigator named Roy Candler drove out to do a visual inspection. Roy had 20 years on the job. He could tell a legitimate complaint from a harassment filing in about 5 minutes. He walked the property, noted in his report that my wildflower meadow was exemplary certified habitat under the State Monarch Conservation Program, and filed his closure report. He also, on his own initiative, entirely separately, forwarded a note to his supervisor about the pattern of complaint filings against this property from a single source. That note went into a file somewhere. Files have a way of mattering later. Meanwhile, Blythe went back to Doyle Fincher, the management company's in-house counsel, and pushed him to file a counter-motion to Sable's quiet title action. She wanted him to argue before the court that the HOA's 2019 internal resolution constituted a valid constructive covenant. Doyle Fincher declined. He didn't decline gently. He told Blythe in a phone call, which she later recounted to the board, according to Weston Pruitt, that filing such a motion would be professionally embarrassing, and that he was not willing to argue a theory with no basis in Tennessee property law before a chancery court judge. He told her the HOA needed to settle. The lien needed to come off. Blythe told him he didn't understand the community interest at stake. Doyle Fincher resigned from the representation the following day. His formal withdrawal letter stated he was stepping back due to irreconcilable differences regarding the legal merits of the board's position. An attorney withdrawing because he finds the client's position indefensible is a notable event. judge's notice. Blythe hired new counsel, a solo practitioner from a neighboring county named Clay Reeves, who specialized primarily in DUI defense and business formations. Not a property attorney, never handled a quiet title action. He charged half of what Doyle Fincher had charged, which told me everything I needed to know about where this was going. I heard all of this because Weston Pruitt told me. Weston was now, for all practical purposes, my inside source on the board's deliberations. He attended every meeting, voted his conscience, and texted Sable updates from the parking lot afterward. Blythe had no idea. 2 weeks until the festival. I kept my head down and kept working. Stacked firewood for winter, rehung the kitchen door so it wouldn't stick, walked the property lines in the early morning cold the way I've done my whole life. The frozen grass crunching under my boots, my breath fogging in the still air, the old house solid on its limestone foundation behind me. Some things endure. That's the whole point. The week before the festival, Blythe tried one more thing. She called the Harlan County Chamber of Commerce and left a message suggesting that the festival's inclusion of my farm was inappropriate given the ongoing legal dispute about the property's community standards compliance. She implied, and this was the move that revealed exactly what kind of person she was, that the county might face some unspecified liability for endorsing a non-compliant property. The chamber director called me to give me a heads up. He was almost apologetic for even relaying it. "I want you to know," he said, "we are not removing the Weston farm from the tour." I thanked him and asked if he'd like to speak at the public forum. He said yes, without hesitating. Blythe also organized a social campaign within the subdivision. She went door to door in the days before the festival, telling neighbors that I was using the festival to make the neighborhood look bad, that I had been hostile to community dialogue, and that it would be a show of solidarity if HOA members attended the forum and asked tough questions. About a dozen residents came. They sat in a loose cluster near the back of the tent, with the slightly uncomfortable energy of people who aren't quite sure why they're there. I saw them when I walked in, recognized some of them from the county road, from the small, ordinary encounters of rural neighboring. I didn't change my plans. The night before the festival, I sat on the farmhouse porch in the dark. Temperature in the mid-40s, wool blanket over my shoulders, the same kind my father used on this same porch. Across the black shapes of the hills, I could see the scattered lights of the county below, the same view that has been here since Elias Weston built this house and sat on this porch and looked out at his own version of this world. I thought about what it means to hold something, not to own it exactly, more to be a temporary steward of something larger than any one life. This house would be here long after me. The job was just to not let the Blythes of the world write their small, petty names on something that belonged to history. I thought about all the people this kind of thing happens to, who don't have a surveyor's eye for documents, who don't have a Sable Okafor, who just pay because fighting seems too hard, too expensive, too exhausting, who let it go. That thought was the one that made me angry. Not what Blythe had done to me, what she had probably done to others before she got to me, what she would do to someone else if nothing stopped her. Inside, on the kitchen table, the manila folder sat open, every document in order, every exhibit labeled in Sable's clean legal notation, the quiet title motion, the AG complaint, the survey measurements, the sworn statements from Weston and Darlene, the 2021 county denial letter, Roy Candler's environmental report, Doyle Fincher's withdrawal letter, and one more thing, something Sable had secured just that week, a letter from the Tennessee Secretary of State's office, responding to a formal inquiry about HOA authority over non-member properties under the Property Owners Association Act. 3 sentences, unambiguous. No HOA has authority to impose dues obligations or file liens against a property that was never subjected to its covenants by a recorded instrument. "Read this aloud at the forum," Sable had said when she sent it. "Read it slowly." I went to bed early, set my alarm for 5. Morning came cold and clean, the kind of October morning that smells like cold stone and fallen leaves. The air so still you can hear the creak at the bottom of the property from the porch. The weather-vane rooster caught the first light and turned, slow and easy, in a breeze that barely moved. I stood there for a moment with my coffee. 185 years. Then I got in the truck and drove to the fairgrounds. The Harlan County Agricultural Heritage Festival occupied 6 acres of the county fairgrounds, and on that third Saturday of October, it was full. Families, Old men in feed caps examining antique equipment with the reverence usually reserved for church. The smell of wood smoke, frying cornbread, and diesel from a 1948 Farmhouse tractor idling near the equipment barn. The specific, irreplaceable sound of a fiddle warming up somewhere across the grounds. It was the most Tennessee morning you could possibly arrange. The public forum on agricultural heritage and property rights was held in the main tent, a white canvas pavilion seating about 200. By 10 o'clock it was standing room. Thaddeus Birch sat in the third row with a notebook. A reporter and photographer from the Knoxville News-Sentinel, Thaddeus had made some calls, were positioned near the aisle. The county historian sat at the panel table, the chamber director, the state agricultural extension director, and at the end of the table, Patrice Hollowell, the Harlan County Register of Deeds, who had been quietly furious about this lien filing since the day it came across her desk. I sat at the table with the manila folder in front of me. Blythe arrived with 4 Ridgecrest Meadows residents and took seats near the front. She had dressed for a public occasion, the athletic wear replaced by a blazer and pressed slacks. She had her binder. She was ready. Clay Reeves, the HOA's new attorney, sat beside her with the expression of a man who had read the full case file on the drive over and was already reconsidering his afternoon plans. The forum opened with the county historian, who spoke about Harlan County's agricultural heritage, the pre-Civil War farmsteads, the pre-plat properties, the importance of preserving what remains of that history. He showed a photograph of my farmhouse taken in 1912. The tent was quiet in the way audiences get when they're actually listening. Then I spoke. I didn't perform outrage. I didn't raise my voice. I am a retired surveyor, and I presented the facts the way I've always presented survey data, clearly, sequentially, with documentation. I told the story of the lien from the beginning. I showed the survey plats on a screen at the front of the tent, the Weston property boundary, the Ridgecrest Meadows plat, the absolute, unambiguous absence of overlap. I showed the 2021 county denial letter on screen, the specific sentence naming my property as outside the HOA's jurisdiction. I showed the signature count on the 2019 resolution, 3 signatures. The HOA's own bylaws required 4. The tent was very quiet. Then Patrice Hollowell spoke. She said, in her official capacity as the recorder of all property instruments in Harlan County, that a lien had been recorded against the Weston property, that the property had never been subject to any recorded covenant or HOA instrument, and that the process by which the lien had been filed was a matter of significant concern to this office. She announced that the Register's office had forwarded a formal referral to the Tennessee Attorney General. Blythe's face changed. The News-Sentinel photographer's camera clicked. Then, Sable Okafor, who had been sitting quietly in the second row, as if she were just another attendee, stood up and asked to be recognized. The moderator recognized her. She introduced herself, stated her role in the case, and read aloud the letter from the Tennessee Secretary of State's office. 3 sentences. She read them slowly, the way she had told me to. No HOA authority over non-member properties without recorded instruments. The lien was without legal foundation. The filing of a lien, known to be without legal basis, may constitute a violation of Tennessee's fraudulent lien statute, carrying potential criminal penalties for the individuals who authorized it. The tent held its silence for a long moment. Blythe stood up. "This is a coordinated smear campaign," she began. Weston Pruitt raised his hand from 4 seats away. The moderator recognized him. He stood, introduced himself as a current member of the Ridgecrest Meadows Estates HOA board, and said in a quiet, measured voice that the board had not authorized this forum appearance, that he and Darlene Gage had consistently voted against the lien, and that he was formally announcing, here, now, before 200 people in a Knoxville newspaper, his resignation from the board, and his intention to call a special membership meeting to elect new leadership. Blythe sat down. For a moment the tent was absolutely still. Then someone in the back started to applaud, slow at first, then building, then filling that white canvas space from one end to the other until it was all you could hear. I looked down at the manila folder. Outside through the tent opening, the Tennessee hills blazed in full October color. For the first time in months, I let myself breathe. The lien was formally released 6 weeks later. Clay Reeves reviewed the complete case file after the festival and delivered the news plainly to the remaining board members. Continuation was inadvisable. The quiet title action was proceeding without viable opposition. The AG referral was open and active. The fraudulent lien statute exposure was personal, meaning it attached to the individuals who had authorized the filing, not just the organization. No responsible attorney could recommend anything other than full withdrawal. The HOA held a special membership meeting in November. Blythe declined to attend. In her absence, the full membership voted to remove her from the board, to hire a licensed HOA management firm with a proper property attorney on retainer, and to formally withdraw all claims against my property. The vote was 28-3. The quiet title action was resolved by agreed order. The HOA stipulated to the court's jurisdiction and consented to a ruling declaring the Weston property free of any HOA covenant, claim, or encumbrance, past, present, or future. The order was recorded with the Harlan County Register of Deeds on December 4th. Patrice Hollowell's office processed it with what I was told was visible satisfaction. The Tennessee Attorney General's office opened a civil investigation into the lien filing. That investigation remains ongoing, but the filing is now a matter of permanent public record, and the people involved know it. The entrance structure setback violation was resolved separately. The HOA was required to file a formal county variance application for the existing gate. Engineering documentation, public notice period, county planning board hearing. It cost them approximately $8,000 in fees. The variance was eventually granted, but the process, the paperwork, the hearings, the expense, felt, in its small way, like the right kind of justice. Blythe sold her house in Ridgecrest Meadows and moved to another county in early spring. She did not leave a forwarding address with the neighborhood Facebook group. The agricultural heritage loan came through in January. The encumbrance cleared, the title clean, the process that should have been simple from the start now finally allowed to be. I used part of it to replace the original slate roof over the west wing, sourcing matching slate from a reclaimed material supplier in Pennsylvania. Elias Weston's house deserved nothing less. The following October, the Weston Farm hosted its first annual Heirloom Seed and Heritage Agriculture Festival. A one-day event, free and open to the public. Seed exchanges, a guided tour of the farmhouse and restoration, a talk by the State Extension Service on monarch butterfly habitat and native wildflower corridor planting. About 230 people came. Children ran through the wildflower meadow. Old-timers traded seed varieties they'd been saving for 40 years. The same fiddle player from the county festival set up on my porch and played until the sun went down behind the ridge. I stood at the edge of it all and watched. I thought about Elias Weston putting these stones into the ground in 1839, about what it means to build something and say, "This is mine, and it endures," about the specific kind of cruelty in trying to take that from someone, not with violence, but with paper, with a bureaucratic process weaponized as harassment, about how many people it works on who don't have the tools to fight back. From the proceeds of the agricultural loan, I established a small annual scholarship in Elias Weston's name, awarded to a Harlan County student pursuing a degree in land management, surveying, or agricultural heritage conservation. The first recipient was a 19-year-old named Jessamine Pryor, who wanted to become a land surveyor. I shook her hand at the County Agricultural Extension Office on a Wednesday afternoon in April, the spring light coming warm through the windows, and I thought that Elias would have liked that. The weather-vane rooster spins in every season. The porch boards creak the same way they always have. 185 years. Some things endure. You just have to be willing to protect them.
That smile she gave him at the end of the driveway, that slow, deliberate smile before she rolled the window up and drove off, like she had done this before, like she already knew how it ended. She just had the wrong man. Garrett didn't yell, didn't threaten, didn't post anything online. He went inside, spread his survey maps across the kitchen table, and started working. Quietly, methodically, and the same way his family had worked at that land for 180 years. And when it was over, when the lien came off, when the board had voted 28-3, when Blythe sold her house and left without forwarding address, there was no celebration, no revenge speech, just a clean title a scholarship in his great-great-great-grandfather's name, and a festival on his land where kids ran through a wildflower meadow that someone had once tried to call a court violation. That's what winning actually looks like. Not loud, just permanent. Here's my question for you, and I'm genuinely curious. If someone pulls this on your property, would you fight, or you just pay to make it stop? Tell me in the comments. And if you know someone dealing with HOA overreach right now, send them this video. It might be the thing that keeps them from writing that check. Like, subscribe, next story is already waiting. Play stupid games, she found out.